Afternoon, everybody, and thank you so much for joining us during your lunch hour. My name is Jan Norval. I'm an executive in the Employment Law Department here at ENS, and we're joined today by Shivani Moodley, a senior associate in the Employment Law Department.
Good afternoon, everyone.
As you all know, today we'll be talking about AARTO and its implications in employment law. Now, at the beginning of the session, I was informed that over 600 people accepted our invite for this session. So it made me feel a little bit like an influencer, but it was brought to my attention that people may be joining for different reasons. One reason, obviously, they're concerned about their employers' liability under the AARTO Act for employment matters, but secondly, that people may be personally concerned about their demerit points here. But regardless of whether you're here for personal reasons or a hybrid of reasons, we're very happy to have you here. Just a few housekeeping issues before we dive into it. Firstly, you'll notice that only our screens are shown. We can't see you, so we'll be assuming that you laugh at all of our jokes during the seminar. And then secondly, while the chat is disabled, there is a Q&A function. So if you have any questions during the presentation, we'll try and answer them during the presentation or answer them after the presentation. We'll be giving the difficult questions to Shivani, and I'll be trying to field the easy ones there. So what has actually triggered us being here? Because AARTO seems like one of those acts that have been around for a long time. You always hear AARTO is going to start at some point. And AARTO is 27 years old. It's actually gone to varsity. It's left the house at this point. But the problem with getting AARTO going has been a number of things. One, they need to get the municipalities up to date with regards to AARTO. And then two, there was a long dragged out challenge to AARTO, which AARTO brought. And it was actually dismissed by the Constitutional Court. So after this was dismissed by the Constitutional Court, the president on the 1st of August made a proclamation which set out now how AARTO, after 27 years, is finally going to come into effect. And there's three dates that are of importance. The first date being the 1st of December. This is particularly important if you live in a city, because that's going to apply to metropolitan municipalities and 69 metropolitan and local municipalities, which means that certain parts of AARTO will come into effect for certain municipalities. So that's metropolitan municipalities and certain local municipalities. On 1 December, there'll be a rollout of electronic infringement notices, processes regarding reduction of fines, and the preparation of the demerit system. So the demerit system is not going to come into effect on 1 December, but certain parts of how traffic offences are dealt with is going to move from the Criminal Procedure Act to the AARTO Act, and that's what we're going to start seeing. Then on 1 April 2026, the AARTO will be expanded to a remaining 144 municipalities, and then on 1 September, which everybody is concerned about, there will be a full implementation of the demerit system, which means from 1 December we can start getting demerit points. So before we start diving into what implications this has for HR managers and legal, in-house legal, particularly related to employment. Shivani, can you perhaps take us through how AARTO is going to work?
Thanks, Jan. So the AARTO amendments, what it's intended to achieve is to create accountability for drivers and for operators who operate vehicles in the course of business. Because typically what we've seen, and I'm sure a lot of us in our personal lives can attest to, you get a fine, you pay it, you cry a little bit about it, but your driving doesn't really improve. So the intention of AARTO is to create better drivers and safer roads. So it establishes a demerit point system. And depending on the nature of the traffic offense or or misconduct, if you will, there'll be certain demerit points allocated to the driver. And they're allocated depending on seriousness. For example, you'll have 1 point for lesser offenses, such as driving an unregistered vehicle which doesn't have an up-to-date license disc. And then 2 to 4 points for more serious violations, such as running a red light, certain levels of speeding. So, for example, over between 21 and 25 kilometers above the speed limit will be 2 points, etc. And then 6 points for the most dangerous offenses, for example, driving under the influence of alcohol. As Jan mentioned a bit earlier, the idea is to decriminalize driving offenses and make them more administrative in nature. But that being said, criminal offenses can still be committed in the course of driving and operating a vehicle. So, for example, when we talk about driving under the influence, that still will remain a crime. Reckless driving, culpable homicide, criminal offenses will remain. But there is also this administrative punitive system that will apply. So once you get to 15 points as a driver, anything beyond that, your license will be suspended for a period of 3 months. So for example, if you get to 17 demerit points, for each point above that, you'll be suspended for 3 months. So 17 points will mean 2 points above the 15, your license will be suspended for 6 months. And simultaneously, you have the risk of the operator license. So in the case of an employer who is required to have an operator card and under the relevant legislation, that would also be suspended. So that poses a business risk and from a continuity and operations perspective. After having had your license suspended twice, you are then in the world of your license being cancelled. And during that period, there's a habitual driver training that is rehabilitation and training that's required. And then you have to apply for a new driver's license. Notably, each time your license is suspended, you'd have to surrender that to the relevant authorities. It is also a criminal offense to drive a vehicle while your license is suspended or cancelled. So that criminal element will remain. Jan, given that we now know what the implications are for individual drivers and potentially operators, what would an employer need to do to create operational controls and implement the system?
So, look, like any good lawyer, the first thing to do is start by reading the Act. Now, for those of you who for the last 27 years hasn't read the AARTO Act, here's a point, particularly for employers out there. So the entire AARTO Act uses the word employee 4 times. 3 times it uses it in relation to an agency which will be created under or is created under the Act, the Road Traffic Infringement Agency. And then it uses it 1 more time, and it uses it in Section 33. Section 33 says any person who employs a person for purposes of driving a motor vehicle may, with the written permission of such an employee, ascertain the demerit point position of that employee in a manner contemplated in the Act. So what this says is that if you employ somebody that drives a vehicle for your company, you need their written consent in order to determine where they are on the demerit point system in order to access their demerit points. Now, I think you're all worried a little bit and think, well, why have we set up this webinar when there is only really one section that specifically deals with employers? But it's not just the word employee which relates to matters of employment. There's Section 17 of AARTO as well, which doesn't just relate to employers, but to everybody. And it says the owner or operator of a motor vehicle who permits any person to drive such a vehicle or otherwise exercise control over such a vehicle without having ascertained the full names, acceptable identification, and residential and postal address of such a person is guilty of an offense. So what it does is it's not just employers, it's personal as well. So if you let your friend drive your car, you need their full details, their ID document, their residential and postal address. But for employers, it means you need to start making a register of those details as well. Because one, it will be an offense. So let's say you'll be liable for a fine or imprisonment not exceeding 1 year if you don't keep these records there. So the Act itself creates two responsibilities on employers. One is, well, if you want to keep track of your employees' demerit points, which I think is just prudent, you need their written consent. And two, anybody who's driving a company car, you need to have their details, ID documents, residential address, and postal address. And I think you will also be responsible for keeping those matters up to date. So there's only two matters in the Act that deal with employers directly from my reading of it. But Shivani, is there anything else, any other employment implications which flow, which may not be directly mentioned in the Act?
Thanks, Jan. Yeah, there are quite a few. You know, even though we've only referred to employees twice in real terms in the Act, there's a lot of things we need to start thinking about. For example, how would an employer deal with the situation if an employee's license has been suspended? Would we deal with that as a matter of incapacity? Would we deal with that as a matter of misconduct? And to that point, employers should start considering updating their disciplinary codes and policies to, for example, provide that driving a company vehicle and then in the course of driving that vehicle, racking up demerit points would constitute misconduct. Obviously, on the first instance, it wouldn't be a dismissible offense, so you'd apply this similar progressive discipline principles. But once you start getting to a point where an employee's license is suspended twice, we might need to consider more serious action. When it comes to incapacity, we might land in a position where an employee's license has been cancelled or suspended and they aren't able to, for whatever reason, obtain a new license. We need to start thinking about incapacity processes. The difficulty I suspect that would be experienced in a lot of workplaces is, well, if you've employed someone as a driver, what reasonable accommodation can you offer them other than offering them an alternative position? It would also be important to have an education campaign within the workplace to explain to employees what their obligations are, what their rights are, what the consequences of getting demerit points would be. And, you know, in particular, it might not be that someone would rack up demerit points while driving for work or using a company vehicle, but their driving in their personal capacity may well affect their employment. Insofar as, for example, you know, employees' rights or drivers' rights, something to consider educating the workforce on is if you receive a notice to say there's been an infringement, you have 32 days within which to notify the relevant authority of who the driver was. So if it is that a friend or a sibling was driving the car and, you know, there's a speeding fine which attracts demerit points, that doesn't necessarily mean that the owner of the vehicle must assume those demerit points. So basically, tell your employees to throw their friends and family under the bus. So that would also help mitigate the risk of these suspensions. As Jan mentioned, you need consent from employees to access the records from AARTO as to their demerit system, their demerit records. Notably, Section 33(2) only refers to employees. So if you're in a situation where you have independent contractors who are driving your vehicles, you'd have to obtain those details from them directly. It does not, we'll see how it gets implemented, but it does not seem that there's a legislative mechanism to obtain that record in respect of people who aren't your employees. And similarly, when we're talking about recruitment practices, one of the questions that should be asked in an application or in an interview is for the individual to disclose what their driving status is. Has their license been suspended, cancelled? How many demerit points have they racked up? Obviously, if the position requires them to have a valid driver's license, because when we're at the job applicant stage, you wouldn't be able to get that information directly from the authorities, even if written consent is provided. There's also the Act also provides drivers the opportunity to make written representations as to why there shouldn't be an infringement notice, or why there wasn't actually an offense. So in reasonable circumstances, encourage your workforce to make those representations within the applicable time frame, because that may also have knock-on effects on their ability to maintain their license. Another thing to consider is when employees are given car allowances, that car allowance should probably be linked to whether they have a valid driver's license. And consideration should be given to the practical implementation. Obviously, if they're driving a company car, there'll be a different system, but if there's an automatic payment made every month through payroll, that should be revisited based on whether the employee is actually allowed to drive during a particular period. And Jan, there's so much that an employer needs to start thinking about, but from a practical perspective, when the Act does come into force, what measures do you think should be in place to create a compliance culture within the AARTO framework?
Sure, thanks, Shivani. So I'll put your question on ice, because we've got 21 questions that's been asked here. So clearly everybody just wants to make you sweat today. The one question that we've been asked, and I'll answer it myself, is that can the consent, so this is the consent in order to determine an employee's demerit points, can their consent be sought and obtained in the employment contract? Or do employers need to require consent at each instance to get the records? Now, firstly, the wording that the Act uses is that it says you must get written permission. So there's no indication in the Act that there needs to be a contract that is there. It can be a unilateral form, in my view, that the employee can fill out. And I think that permission can be, I give permission for you to, at any point, look at my demerit points. It doesn't have to be an ad hoc system there. Then another question that we've been asked about is there's a lot of questions that are asked about the use of private vehicles. The use of private vehicles is not something that the employer needs to keep records of. It's only if the company is the owner of that vehicle. So if you're giving your employees driving allowances, or the employees use their private car for work purposes, you don't have to worry about the record keeping requirements. So I'll maybe pause there. We've gone up to 28 questions. If we don't get to all the questions here today, then we're hoping that you'll contact us afterwards, but please don't feel that we are ignoring you. Regarding Shivani's question in relation to risk mitigation strategies, the first thing I think that would be of value is appoint an AARTO compliance officer. Now, the reason I say that is because I know on this call, the majority of people are either in the HR department or they're in the legal department. And I know as an employment lawyer, you blame everything on HR. Failing that, you blame it on legal. And what I can just see practically happening is HR is, as Shivani says, you're going to put it in your recruitment documents, particularly for drivers, put in your recruitment documents that the employee consents to having their demerit points checked. The person is appointed as the driver, and then you're going to run into, but is it actually going to be the warehouse or operations that is going to be responsible for periodically checking demerit points? Or is it going to be HR that's going to periodically check these points? So it's important to have somebody that is responsible for this, not just for the checking of points that needs to happen, we think, prior to employment and during employment, but that these periodic checks on the demerit status actually happens. Because you've got 32 days within which to nominate the employee to whom demerit points must go to. So you don't want a situation where John is on leave, you miss the 32-day period, and then the company gets those demerit points. And if you're a large company, you can rack up those 15 demerit points very quickly and have your operator's license suspended. So it's important that you have people who are responsible for checking on demerit points and for ensuring demerit points are assigned so that things don't fall through the crack and you inadvertently lose your operator's license. Secondly, also a practical thing, because service can be done via mail, check your mail promptly. Because you only have a set time period within which to assign these demerit points. So make sure that whoever you appoint, make sure that you go and collect your mail quickly. Further, obviously, nominate your drivers for fines because you don't want your company to rack up those demerit points. And as Shivani has mentioned as well, I think there's a lot of value in educating your workforce about their rights under the Act and how to practically go about disputing any fines that there may be. Because ultimately, what you want is you don't want to end up in a situation where one of your drivers has a suspended license. So empower them in order to dispute any fines that there may be, so that you're not running into incapacity or misconduct issues as Shivani has mentioned. So maybe we'll dive into some of the Q&A section here, but I'm going to jump the queue in front of everybody, and I've got a few questions myself. So Shivani, if an employee comes to you, they have now had their license suspended, and they are due to go for one of these driver rehabilitation programs, but they have no annual leave left. How's the employer going to deal with something like that?
So Jan, there hasn't been any statutory provision for leave that employers are required to give employees for the purposes of attending this rehabilitation program. So the ordinary principles relating to absence from work would apply. So if your policy makes provision for unpaid leave in certain circumstances, you'd allow them to go on that basis. Employers might want to consider granting a special form of leave, paid leave for this purpose, depending on, the reasons why the demerit points were racked up and the like. But, that should really be a very exceptional situation, because you also don't want to encourage people to rack up high demerit points in the hopes that they'll get paid leave for attending a driver's rehabilitation program. So in the ordinary course, if someone needs to excuse themselves from work, unable to tender their services, but don't have annual leave, you'd apply the ordinary process that you would apply to that situation. Jan,
Fantastic.
One back at you. Can an employer simply state that a driver who goes above 15 points commits serious misconduct and then that's a dismissible offense?
So as Shivani mentioned, I think there's two options to look at once your drivers become suspended or they get their license taken away fully. It's incapacity, because obviously the employee is no longer able to legally work if they are a driver. But incapacity, as a lot of you will know, is, I think, a bit more of a difficult dismissal process to go about. Why? Because you need to consider alternatives that are there. And you can see the world where the driver says, yeah, well, it's fine. Just let John drive. I will sit at the desk and do the admin for the next few days. So I think incapacity, it's an option, but it may be something that makes life more difficult than it should be. I'm a big fan of misconduct in general because I'm an employment lawyer, but I like the misconduct route more because it's not, you don't have to look at alternatives. But I think you need to structure this properly in your policies. To just say, well, 15 demerit points, misconduct dismissal, I think you can get away with it, but I think it would be better to implement some form of progressive discipline in relation to this. So if an employee, put it in your policy and say any employee that reaches 60 merit points while driving the company car, that's a warning. If you reach 10 demerit points, then it's a final written warning. And if you reach 15, then we're going to consider dismissal on it. And I think implementing that as a rule in your workplace is fair, because it must surely always be acceptable for an employer to say to its employees, when our drivers drive our cars, we expect them to drive in a lawful manner. And if they don't drive into a lawful manner, there will be progressive discipline, which will be applied, and eventually that progressive discipline will result in dismissal. Shivani, one of my favorite topics is collective agreements and collective labor law. So we know that the Act requires written permission from the employee in order to access their demerit points. What if I, during wage negotiations, just slip it into my collective agreement with the union? Do you think that will suffice? And even more so, if I've got a majority union in the workplace, I extend that to through 23(1)(d), and I get that collective agreement to apply to my entire workplace, even if some of my employees are not members of that union.
Yeah, and in case the Star Wars behind you didn't give away that you're a nerd, that question did. So I think, strictly speaking, probably yes. But what it really turns on is the practical implications and implementation of getting access to these records. We all know what government bureaucracy is like, in particular in South Africa. I suspect that they're going to want to see written consent in a very specific form or manner that is probably signed by the individual in question. So from a strict legal perspective, I think you're right. I think that kind of written permission would be enforceable in law. Whether administrators would accept that is a different question. And I noted one of the questions in the Q&A is, would it be appropriate to obtain consent in an employment contract, or is there a different form, and how does the AARTO 27 form tie into that? And there are going to be new forms that are published shortly and implemented, and those new forms make provision for attaching written consent from an employee. So I think just as a practical measure, as much as we can include it in an employment contract, and it is probably advisable to include various driving-related contractual obligations in the employment contract, for ease of administration, it would probably just be better to do a one-page written consent form to be signed by the individual employee when they start employment, together with, for example, the EA1 form if there's a designated employer, part of the pack that they're required to sign.
I'm going to try and dive into some of the questions here. I think there's one question here. I won't say from whom it is, but that person is clearly already worried about some demerit points having racked up. The question is, how long are demerit points valid for? So my understanding of that is, and Shivani, correct me if I'm wrong, is that I think it's every month or every 2 months. So if you lose one demerit point, is it 1 or 2 months? I just can't recall off the top of my head.
It's 1 month, yeah.
1 month. So every month you lose one demerit point. So if you're currently sitting on 10 demerit points, next month you would then sit on nine demerit points. Then there's a question here. Somebody's worried about their HR budget. Who pays for the rehabilitation program if the fine was for a company driver driving a company vehicle? Shana, what's your thoughts on that?
Honestly, that's a good question. I haven't applied my mind to it, but I'm not sure that there is a cost associated with the program.
Yeah, So it's not yet been clear, because a lot of this needs to also be set out in regulations, and you'll see that in the Act itself, it also talks about things will be done in the prescribed manner. And I can see one of the questions is, well, how do we actually look at an employee's demerits? Well, that's hopefully going to be sorted out in between December and September next year. So there will be a prescribed manner for how it's done. In relation to the rehabilitation program, we don't have clarity on that yet. I imagine it may be the same as, paying for your driver's license. So any fee that would be there would be specific to the employee itself or themselves. I don't think there would be any obligation upon the company in order to pay for that. Then there was
to that point, before you move on, to the extent that we're in the incapacity world and an employee says, well, I can't actually afford to attend this driving rehabilitation program, to the extent that there may be a cost, something to consider is providing the employee with an advance to make that payment. It's a reasonable accommodation measure. For example, sign a Section 34 deduction and take it from there. So that would probably be one of the accommodation measures one might want to consider if we are in an incapacity world.
I think that's an excellent point, and I think that drives home as well why put in your policies so that you can make it misconduct. So you're not having these discussions as to whether you should be paying for rehabilitation programs or not. Then, Shivani, there's another question here that says, should the employer not require an employee who drives a company vehicle to disclose any demerit points that they may acquire while driving their own vehicle?
I would say that any employee who is required to drive for the purposes of their job, whether it's a company vehicle or whether it's their own personal vehicle and they do a reimbursement or there's a car allowance that applies, if your job requires you to have a driver's license and drive a vehicle, I mean, a good example is what we do. We drive to court, etc. Look, in the metros, it might be slightly different if there's Uber and stuff. That should be required. You should require your employees to disclose your demerit points on a regular basis, because that does then affect their ability to perform their functions, regardless of whether they're driving a company vehicle.
Exactly. One of the questions, it's not here, but I was asked this question this week, in fact, is that should you not have a driver's license and you then are caught not having a driver's license, you would then get 60 merit points. And I say, well, when you then apply and eventually do get your driver's license, do you then start with those 60 merit points? And the answer to that question is yes, because the demerit points attach to the person with the driver's license, or if it can be to the operator if they do not identify who the driver is. I can see in the questions here that somebody has pointed out, I think, a good point regarding misconduct. It says that misconduct will be problematic if the infringements which result in suspension of the driver's license took place while the employee driver was off duty. I don't believe that you can prove a causal link to misconduct while off duty. In that instance, it may be easier to prove incapacity or failure to meet inherent requirements of the job. I think that is a very good point that is made. So with my misconduct example, I think it will only relate to if they are driving the company vehicle. Obviously, if they're driving the company vehicle outside company hours, I think you can still hold it to be misconduct because they're driving the company vehicle. But if they're driving their personal vehicle, then you may want to start looking at the incapacity part. Any questions that's caught your eye, Shivani?
Yes, the one was, are there gradings of demerit point systems for the offences that may be committed? And yes, so there's what is called Schedule 3. It's and colloquially called a book of charges. There's a very long list of all the different types of offences, and the points that would be accrued is fixed for each type of offence. So there isn't any discretion on the part of the authority or a traffic officer or anything along those lines. Then there's also a question, would the demerit points still fall away after each month if you accumulate more demerit points during that same month?
So I think that's a matter of maths. So it's, if you accumulate 3 during the month, but you lose 1 during the month, then you would then accumulate 2 during that month.
Yeah, I
Is
think
my
it's
understanding
comparable
of it.
to accrual and forfeiture of annual leave. I think it's a
Yeah.
similar type of mathematical calculation. And we can
Then
see from some of the questions that people are really worried about their own personal driving status, because the question is, what is the status of all fines, and do we start off on a clean slate?
Yes, so you do start off on a clean slate. It's only on September next year, when the demerit point system comes into effect, that you start accumulating points. So it's not old, and obviously the fines you get now are you must still pay them, or you must still dispute them, and you will dispute them under the old Act as well. That's it. Then there's a question: does this, and I assume when they say this, apply to leased company cars? So I think that probably refers to the requirement to keep information of employees. So the requirement to keep information of people who drive your cars is related to the owner or the operator of the vehicle. So leased cars is unlikely to apply to. This is going to be Avis's problem.
And then, Jan, I think we've answered this question indirectly, but let's address it directly. How does this impact proxies and representatives for company vehicles? Their ID is on record and all fines are issued on their ID number.
So I think as long as you just need to make sure, all that AARTO, because this is how I'm thinking about AARTO, because what it actually is it's government saying that we're going to pass enforcement along to companies. We're going to scare companies through this demerit system and say, company, you must say who the infringer is, and you must keep the details of the infringer, and you must tell us all these things. So in relation to proxies, I don't think there's much that changes from it. You will have their details, and you will still point them out as being the person to whom the demerits should go to.
An interesting question that I think we should address is, if the demerit is due to the company vehicle fault and the employee gets demerited, how should that be dealt with? And I think a nice example of that is one of the reasons you can accrue a point is for driving a vehicle without a seatbelt. Well, if there's no seatbelt in the vehicle, is it the employee's fault?
Yeah, that's interesting. I mean, I also thought about that along the lines of if the car is overloaded, but it's a company car that's overloaded, and it's overloaded with company matters. Now, I think at the end of the day, it probably still falls upon the driver, because the driver shouldn't be driving a vehicle that doesn't meet legal requirements, in that it doesn't have a seat belt or it is overloaded. So as much as it may be the company's fault that the vehicle is in a state of disrepair, I think the driver is entitled to say, I refuse to drive that vehicle because it doesn't meet legal requirements. And that would be a lawful refusal to follow. That would be, I think, a reasonable refusal of an instruction, because the instruction is unlawful.
And I think, if we get to a point where this person's license is being suspended, it would be unfair to take disciplinary action for arriving at this point, when part of the reason why they have demerit points and a suspended license is because the company's own conduct and placing them in that position. Because I understand, a driver might not feel that they have the ability to refuse to drive a car, for example.
Exactly. I haven't read this full answer, or this full question, so I'm going into this one blind. Yesterday, our driver left his license at home, and just his luck, he was pulled off. The officer wanted to impound our vehicle. He was after we spoke to the officer given a fine. So if this happens when AARTO is in place, and this happened, will he still be given the fine, receive the points, and can they impound the vehicle not on the driver's name? So I'm not so sure about the impounding of the vehicle, but if he's been issued that fine and that fine's been issued in his own personal name, then I don't think there's much that the company needs to worry about other than that his demerit points will increase in that scenario. If the fine is, however, issued in the company's name, the company will within 32 days have to make sure that it's assigned to the employee. Shivani, your thoughts?
Yeah, no, fully agreed. Fully agreed. So that problem would persist, but it would be demerit points accruing to the driver.
Yeah. Then I'm just going through some of the questions here. Shivani, shout if you see anything that we haven't answered yet. Here's one. If the driver knows the vehicle is non-compliant, but was forced by the employer to drive the vehicle, what advice can be provided to the driver to protect him or herself of demerits? Well, I mean, forced, I mean, if it's, by the barrel of a gun, then I think that's, perhaps a different story. But I think just the employer saying, well, you need to do your job, you need to drive this unroadworthy vehicle, I think there is a responsibility upon the driver to say, no, I'm not going to do that. Not only is it a health and safety issue, he is well entitled to refuse unlawful instructions. So, unless it is by some sort of, barrel of a gun scenario, I think the word forced those demerit points are going to fall upon the employee.
Yeah, I think equivalent comparison is, what if your employer forces you to bribe someone? You're still going to be held liable.
Exactly. What other countries use the demerit point system? I know the UK uses the demerit point system. Whether ours is based upon the UK one, I'm not 100% sure, but it is definitely used in the UK. And I know in some countries, for instance, and Australia is another one where they do it as well. Where I know that in Australia, at least, once people start racking up demerit points and they get to say 9 demerit points, they just don't drive their car at all because they are so scared of losing their license, and they become very familiar with public transport.
So there's a question, will RTMC not provide the information when the company conducts the reference check process during the recruitment process, like they do with the confirmation of the validity of driver's license? So my sense of Section 33(2) is that they may only disclose it if it's your employee who has given written consent. So if we're at the application stage, they don't have the legal authority to provide that information. Whether they practically do so regardless is a different question, but from a strict legal interpretation, they're not permitted to do so. And for that reason, you'd have to rely on disclosures by job applicants.
Yeah, I fully agree with that. And then here's an interesting question. Can pedestrians also get demerit points for not following the rules of the road? Now, my reading of the act is that no, pedestrians can't get demerit points, but obviously if it's the pedestrian's fault that you are being fined, then you would then dispute that fine.
Although, like the way pedestrians are in this country, like everyone would be suspended from walking.
Exactly. Yeah, I'm trying to see. Do you see anything else that we haven't answered yet? I'm sorry if we've missed your question.
Yeah, I think we've covered the majority of it.
I think we've covered it. Well, in that case, hopefully we can then send you to finish your lunch a bit earlier today. But I hope you've enjoyed this and found this useful. In relation to individuals who've asked for information regarding some of the information that went a bit quickly here, specifically regarding implementation dates and so on, you're welcome to reach out to us individually, and we'll happily answer your questions in relation to that. But we'll obviously be keeping everybody informed through insights and so on as this continues. But yeah, up until then, I guess we all need to drive a bit safer.
Thank you, everyone.
Thank you so much. Bye.